Have you been on the receiving end of opposing counsel's abuse during a deposition? In this short video, I'm going to discuss some of the most common abuses that attorneys experience during a deposition. And then I'm going to give you 5 ways to effectively deal with them. Hi, I'm Julie Brooke, CEB's blog manager. Deposition abuse has many faces. Some counsel take advantage of the absence of a judicial officer by engaging in obstructive behavior, such as making frivolous objections, improperly instructing a witness not to answer, and making unnecessary speeches. Abusive counsel will call frequent recesses, supposedly to help consult with a witness, when in fact they're actually coaching a derailed witness back on track. When there are several attorneys on the other side, they may make multiple objections to try to distract from the thread of your examination. Without a judge or jury to start fidgeting, abusive counsel may engage in time-wasting activities such as going through every piece of paper, every conversation, and every even remotely relevant event. And of course, abusive counsel may display blustering and angry behavior that they would never dare show in court. What should you do if you encounter deposition abuse? Well, here are 5 tips for dealing with it. First and foremost, don't allow opposing counsel to bait you. If you encounter deposition abuse, firmly but courteously note it and then go on with the deposition. If opposing counsel is improperly instructing a witness not to answer, you could stop the deposition and seek relief from the court, but that doesn't help you much if you have more questions to ask. The better approach is to insist on an answer or an instruction not to answer on the record, and then continue with the deposition. You can ask the reporter to mark every instruction not to answer, so it'll be more easily found later on. Counsel makes speeches for the record for a lot of reasons: to impress a witness or their client, or just to blow off steam. You can limit these unnecessary speeches by going off the record to have an informal discussion of a discovery difference. And then you can go back on the record to either state resolution of the difference or each side's position. If you anticipate discovery abuse, consider video recording the deposition. Videoing has a calming effect. Abusive counsel know that every sneer and angry tone will be picked up on video. Ultimately, the best solution for discovery abuse is a firm supervising court. More and more courts are allowing attorneys to schedule telephone conferences with a judicial officer to resolve discovery disputes. Now, if money is not an object, you might consider having a referee or a special master attend selected depositions. They can make immediate rulings that'll be subject to later court approval. If deposition abuse is relentless, you can tell opposing counsel that if the abusive tactics don't stop, you're going to adjourn the deposition to seek a protective order from the court. In civil cases, cross-examination at trial is heavily dependent on what a witness said at deposition. So you want to make sure to get the most out of your deposition examination. Don't let opposing counsel's behavior unsettle you. Anticipate some level of deposition abuse and be ready to calmly combat it. These tips and many others for taking and defending depositions can be found in CEB's California Civil Discovery Practice. Also check out CEB's Handling Depositions, a step-by-step guide through the deposition process. Thank you for watching, and from all of us at CEB, we're proud to be your partner in practice.